Hey everybody. We are here for sentencing of Edrick Faust. Pinned at the top of the chat if you're watching live, and then also in the description of the video is a link to a Give Send Go that was set up. I saw Colin Miller share it. I believe attorney Ahmad Cruz has also shared it over on his Facebook. So if you can and would like to donate, that is the correct place to go for it. Let's see. Turn this back up. Let me get a banner going. Yeah, I think the appeal is garnering a lot of attention. I mean, it's only been, I mean, this is what, 2 days since verdict? So, I mean, I have no information, no insight. I wouldn't even assume that Foss has made a decision on who he'd want to hire, who he would hire, and who would agree to take the case up. So, I mean, I honestly have no insight on any of that, but I do know that a lot of waves are being made. Oh, they cut us out already. Yeah, where's the ginger ale? I heard that there were people that are local to the area that were showing up. They were wearing all black. I don't know how many people can fit in the courtroom though. It seemed like the courtroom was already crowded like the last week of trial. So I'd imagine with sentencing, there might be even more people trying to get in there. Yeah, and everyone's like, make this quick. I don't see how this could go that long. She scheduled it for 3 o'clock. I mean, I don't know if they'll stay late for it, but the court hours are till 5 p.m. So I think that was the idea, Freedom Ring, all black signifying a morning of the result. All right, now we're back on the seal. Okay. Well, that worked. Oh, they're taking us away again.
All right, good afternoon, ladies and gentlemen. We are here for the sentencing portion regarding the state of Georgia versus Edrick Faust, SU 24 CR 0547. The jury having returned a verdict of guilty on all counts in the indictment. Ladies and gentlemen in the audience, I want to take care of a few preliminary matters before we get started. The first is that no one in the audience, with the exception of media who have been granted a Rule 22 permission, can have their cell phones out and can have their cell phones out. So the first thing I want everybody to make sure is that if you have a cell phone and you are not the media who has been granted access, to put your cell phone away, please. And also, while you're doing that, to make sure that it is in the off position. I would appreciate everybody's cooperation on that. If there is anybody, of course, and I've mentioned this before during the course of all of our proceedings, if anyone does violate that portion of this court's order, having their cell phone out and certainly even using it, you will be escorted from the courtroom by the deputy and not allowed to return. The second thing I want to remind everyone, as I reminded everyone the other day who was here, is that this is a court of law, and certainly the court expects everyone to act accordingly. There will be no disruptions whatsoever, no outbursts of any kind, no yelling, no screaming, and no disruptions like that. If that does happen, I will stop the proceedings. The Sheriff's Department will escort that person or persons out of the courtroom. Everybody certainly was in full compliance the other day when the verdict was read, when I gave this same instruction. And I certainly appreciate everyone's abiding by that order very much, and I'd ask you certainly to do the same today. Is the state ready to proceed?
State's ready, Judge.
All right, Mr. Cruz, is the defense ready?
I have no other choice, Your Honor.
All right, thank you, sir. Mr. Faust, I'm going to address you now, sir. I want to tell you that, as you know, you have been convicted of all 12 charges as listed in the indictment by the jury, returning the verdict. I want to tell you that you have the right to pursue an appeal. If you cannot afford an attorney, the court will appoint an attorney to represent you for an appeal. I want to make sure you understand that filing an appeal has time limitations. You have 30 days from the date of sentencing, which will be today, to file a notice of appeal. Filing a motion for new trial also falls under that category of 30 days after the conviction sentence is entered. You also have 4 years if you choose to file a habeas corpus petition. If you cannot afford an attorney to represent you, the court will appoint an attorney for you. I certainly know that you will speak with Mr. Cruz today and other days about your rights of appeal, but I wanted to make sure you understood them. Do you have any questions for the court about those things? Thank you, sir. All right, if the state is ready to proceed, you may do so, sir.
Thank you, Your Honor. Judge, what the state would intend to do as it relates to our presentation of evidence concerned with sentencing is to begin by discussing the ranges and the counts on which Mr. Faust is to be sentenced from the state's understanding. At that point, Your Honor, I would tender in certain certified convictions in aggravation of punishment. Mr. Cruz has been provided copies of those. We would then offer 4 victim impact statements, Judge, from Miss Virginia Baker, Mr. Adam Baker, Miss Meredith Schroeder, and Mr. Kevin Baker. And after the victim impact statements, the state would make its recommendation to the court. As it relates to count 1, malice murder, the sentence is mandated by law as of January 19th of 2001 would be a sentence of life imprisonment. Counts 2 through 5, the felony murder counts, as a matter of law, since Mr. Faust was found guilty of malice murder, would be vacated. Mr. Faust is thereafter still eligible to be sentenced for each of the felonies that underlied those felony murder counts. That would be the burglary, aggravated sodomy, 2 counts, and then the rape. As it relates to the sentencing range for burglary being count 6, that would be up to 20 years. Count 7, the aggravated sodomy as it existed on January 19th of 2001, the state's understanding of that is that that would be a serious violent felony subject to the provisions of 1710 6.1 at the time, which indicates that when an individual is convicted of a serious violent felony, if they are sentenced to anything other than a life sentence, they are not parole eligible for whatever that sentence is that is imposed by the court. And the range on aggravated sodomy at the time was 10 to 30 or life. As it relates to, and that would be the same for count 10, Your Honor. As it relates to count 8, the rape count, that would be 10 to 20 or life. As it relates to count 9, the aggravated assault, that would merge with count 1 for purposes of sentencing. We've already covered the range on count 10. Count 11 would be up to 20 years, and count 12, possession of a knife. I'm sorry, count 11 was the arson in the first degree. Count 12, the possession of knife during commission of a felony would be 5 years, Your Honor. And Judge, would the court like us to continuing numbering exhibits from the exhibit number in the trial, or to start with 1 for purposes of sentencing?
That's a great question. I think we should continue with the numbers that we've been going on. Do you have the last number that was entered?
I do not.
Okay. Okay. We can do that. Sure. I think that sounds fine. Ms. Satterfield really is in charge of all of those numbers. That's important for her. So we'll start again with 1. She thinks that would be best. So go ahead and label whatever document you have as State's Exhibit 1, and then follow with any other exhibits you have in numerical order.
Thank you, Your Honor.
All right.
And Your Honor, I've labeled for purposes of sentencing State's Exhibits 1 through 6. Exhibit 1 is certified conviction from criminal action number 93 OR 36B, which was a sentence entered on an attempted robbery charge with a sentencing date, original sentencing date of June 7th of 1993. This document was for a first offender sentence. It was later adjudicated guilty. In State's Exhibit 2 is 96 OR 165J.
Yes.
I would object to the state attempting to use prior convictions and aggravation of sentencing. If my recollection doesn't fail me, we didn't receive notice that the state intended to use Mr. Faust's prior record for sentencing either the last day of trial or the day before the last day of trial. The state provided us with documentation stating that they intended to use Mr. Faust's record in aggravation of sentencing. As the Honorable Court is aware, under OCGA Section 17-16-4, Section A5, the law states that the prosecuting attorney shall no later than 10 days prior to trial or at such time as the court orders, but in no event later than the beginning of the trial, provide the defendant with notice of any evidence in aggravation of punishment that the state intends to introduce in sentencing. And that is a shall statute. The state failed, unless they could show something, because from what they gave me 2 days ago, 2 days before the end of trial or the last day of trial, that was my first time seeing those documents. But the state hasn't met the notice requirement to introduce evidence in aggravation of sentencing under that statute, Your Honor. So I would ask that if the state wants the Honorable Court to proceed with sentencing, that's fine, but I would ask the Honorable Court not to consider the state's evidence in aggravation because they failed to follow the proper procedure for admission of same. Thank you, Your Honor.
Thank you, sir. Any response, Mr. Yelman-Chile?
Yes, Your Honor. I don't have both of the dates in front of me, but the state provided its first notice of intent to use any convictions contained in Mr. Faust's criminal record in aggravation of punishment as part of its discovery certificate that was filed on, I believe, April 2nd of 2025. Subsequent to that, we provided a more specific notice that listed 3 convictions coming out of Clarke County, and then we amended that notice with the second notice of intent to use prior convictions in aggravation for recidivism, which doesn't necessarily apply here for purposes of impeachment as well. But
This is the only one I see is with 3 cases, and they're not cases that he's already tried to read into the record. But okay.
the original notice is from April 2nd of 2025.
Thank you. Yes, sir.
I would ask the Honorable Court not to take Mr. Yalamachile's word for it. If the Honorable Court could review the record to make sure that it's accurate. I disagree
April
with that
2nd,
position,
20?
but I may be mistaken. I would just ask the Honorable Court to confirm.
Okay, thank you, Mr. Cruz.
April 2nd, 2024, 2025. So there we go. Oh, is it not? Oh. So, notice of impeachment, recidivist notice, and that's it. And this was filed before the specification of those 3 cases.
So I'm going to overrule your objection. I'm also holding in my hand the state's second notice of intent to use prior convictions in aggravation of sentencing, and that
I
was
don't
filed
see
on
that
October
one.
the 2nd. So I have one of them actually in my hand, but I have reviewed the record, and Mr. Yelman-Chile is correct, sir.
Yes, ma'am.
All right, thank you. You may proceed.
And Judge, so State's Exhibit 1 was a conviction for attempted robbery, Your Honor, with the date that I noted.
I don't see, and she said October 2nd that the amended was filed. Like, I searched intent, I searched recidivism. I don't see an amended one filed. So I only see the one that I pulled up on the screen at first with the 3 cases on it. Also, thank you, Positive QB. Thank you for the super. Says, I somewhat want him to speak and say he's been wrongfully convicted and he hopes the real killer gets caught. I mean, it's not like she's gonna be able to make his sentence any worse than it's gonna be, so. Maybe, what is there to lose?
Was a conviction for attempted robbery, Your Honor, with the date that I noted. State's Exhibit 2 is a certified conviction regarding possession of a firearm by a convicted felon and other offenses from 96 OR 165J, again, out of the Superior Court of Oglethorpe County. Then we come to the 4 Clarke County convictions that the state intends to admit for aggravation. State's Exhibit 3 is SU 01CR0298. This was an aggravated assault committed on February 4th of 2001 involving cutting or another individual in the neck area and The sentence date on that particular offense, I believe, was September 6th of 2001. Obviously, the offense date is within a couple of weeks of this murder. And then State's Exhibit 4 is SU 11 CR 0744. This is a certified conviction, again, for Mr. Faust for a felony. And it is a conviction for possession of cocaine as well as driving while license suspended and misdemeanor obstruction of a law enforcement officer. State's Exhibit 5 is another certified conviction. This is SU 13 CR 0203 out of the Superior Court of Clarke County. And this is a conviction for possession of cocaine with intent to distribute, as well as misdemeanor obstruction of a law enforcement officer. And Your Honor, the sentence date on this particular case is November 6th of 2013. And then State's Exhibit 6 is SU 14 CR 0774. And it's for a felony driving while license suspended, Your Honor. The conviction date of this case will be November 26th of 2014.
Yes, sir.
I just pulled up the notice that the Honorable Court mentioned from October. It only mentions 3 offenses. That's the aggravated assault. That's the VGCSA, 2 counts. I don't, just wanted to let the Honorable Court
That
know.
was the only one I had in my hand, but I have reviewed the record.
But where's the amended
I just wanna make
notice?
There's an amended notice as well, Mr. Cruz, but the one that I was referring to is the one I have in my hand.
Correct. The amended notice only
misleading.
received that 2 days before the end of trial, Your Honor. So we're asking that those convictions not be considered. The 3 that's in the notice filed in October, obviously that meets the statutory timelines. The ones that they gave me 2 days before the verdict came down, that does not meet the statutory timeline, Your Honor. So I'd ask the Honorable Court to reconsider its ruling.
Thank you, sir. Any response to the objection again, Mr. Yelmichilli?
Well, again, Your Honor, if we go back to, and I believe it's April 2nd of 2025, but the court has the record in front of it. As part of the state's discovery certificate, we provided notice of both impeachment, aggravation, and I believe also recidivism for any convictions that were contained in Mr. Faust's criminal history. There's no, to my knowledge, no subsequent requirement of the state to make a more specific notice, but we chose to do so.
Yes, sir.
The law requires a specific notice. So there is a requirement for that, Your Honor.
I'm not sure that's correct, Mr. Cruz, and I'm going to overrule your objection and allow the state to continue.
All right. And so, Your Honor, if I could approach, I have states
You may.
1 through 6.
Thank you. You may proceed.
Thank you, Your Honor. At this time, we'd ask the court to hear victim impact statements, beginning first with Miss Virginia Baker.
Good afternoon, Your Honor.
Good afternoon.
I am Tara's mother. I will always be Tara's mother. And I'm afraid my emotions are about worn out after these 25 years of pain. And so if it is okay, I have asked my son-in-law to read my statement for me, if that would be all right.
Yes, ma'am. That is certainly all right. Go ahead.
Thank you, Your Honor, members of the court. There are no words to fully express the horror of what this monster did to my daughter, Tara. For weeks, I have sat in this courtroom, forced to look at evil, to hear details I never wanted to know. I have endured it only for her sake. January 19, 2001 was the collision of pure good and incomprehensible evil. Over these 25 years, the truth has emerged slowly, each new piece more terrible than the last. The question that never leaves me is why? I have asked God this question thousands of times. I still have no complete answer, and the pain remains. As a mother, I cannot bear the image of Tara dying alone, frightened, calling for help that never came. Night after night, I dream of carrying her burned and broken body, walking endless roads trying desperately to find someone who could help, someone who could bring her back. I have begged God to trade my life for hers. She is gone. The emptiness she left is vast and unending. Tara was intelligent, kind, dutiful, and loving. She worked hard toward her dream of becoming a lawyer so she could help others. Yet she never lost her generosity or her caring nature. Her life was full of promise and light. The person who took her lived in complete opposition to everything she stood for. His actions were selfish, depraved, without compassion or regard for the lives he destroyed. He did not only end her life and her dreams, he tried to erase her completely by setting the fire. Our family had never known violent crime before that day. Her absence still wounds her siblings, her friends, and all who loved her. The pain is constant, even in moments that should be joyful. I will never forget sitting beside her closed casket, praying it was all a mistake, that we would open it and find it empty. Though I begged to open the casket to see my sweet girl one last time, my husband and the funeral director protected me from seeing the devastation that Edrick Faust had caused. The impossible hope that somehow she was not in that casket was the last thread I clung to before accepting she was truly gone. After 25 years of living in the shadow of this loss, praying, waiting, and enduring, the final chapter has been written today. As the district attorney reminded us, it was the jury's solemn duty to hold the pen and write the correct ending to this tragic story. They have done so, bringing accountability at last and allowing light to pierce the darkness that has shadowed our family for so long. Tara's beautiful soul is now safe with our Lord. Her short life was filled with love, and that love endures in every heart she touched. I thank God for the grace that has carried me this far. I thank him for my remaining children, Tara's siblings, and I thank him for my grandchildren. We all thank him for the legacy of light that Tara left behind. Tara was, and always will be, deeply loved. Such a beautiful life, so full of promise. Thank you for your time, Your Honor.
Thank you. Mr. Cruz, anything from the defense with regard to this victim witness?
No, ma'am.
All right. Mr. Yalamichilli, you may call your next witness.
Your Honor, the state would call Adam Baker.
On January 19th, 2001, my beloved sister, Tara Baker, was stabbed, beaten, strangled, raped, and finally set on fire. That horrific act was not where the tragedy ended. That is where it began. Tara was an extraordinary human being, beautiful, compassionate, driven, and hilariously funny. She was the best of us. I have never known anyone with a purer heart. Tara and I were more than siblings. We were best friends. From the day I was born until the day Edrick Faust ripped her from us, we were inseparable. She cheered me on at every step. My decision to join the Air Force, my dreams of flying, it was her dream for me to become a pilot. I remember how she beamed with pride after I joined the Air Force. I remember coming home on leave and her giving me the biggest hug. We talked so much about my training and what things were like. I also remember the moment she saw my dog tags and truly understood what they meant. She grew quiet. She cried. It was the first time she ever considered that my life could be cut short. Neither of us ever imagined it could have been the other way around. Being far from home meant I was alone when I learned of her death. My father was desperately trying to contact a military chaplain to sit with me when the news came, but I called him first. The cries of anguish I made during that call haunted him until the day he died. I still have nightmares in which our roles are reversed and I am the one making that call. hearing the pain, unable to hug my son or comfort him. I remember the fog of arranging a flight back to Georgia, the long journey home, watching people board planes and go about their day oblivious. The flight attendants offered pretzels or cookies. All I could think was, I want my sister back. The entire flight, I dreaded one moment above all, seeing my mother. When I finally reached my parents' house and I saw her face, the anguish there was something no one should ever have to witness on their own mother. In hysterical grief, she held me for what felt like days, weeping and wailing. That evening, through her tears, she begged me to achieve my dreams because Tara could no longer achieve hers. Our focus is only Tara could have inspired me to do. I made every rank as early as military regulations allowed. Eventually, I was accepted to officer training school. My family attended my graduation. Tara was not there. I went on to flight school and earned my wings. At graduation, my family proudly pinned those wings on my chest, but Tara was not there. I met an amazing woman whom Tara would have adored. We married. At the wedding, we took family photos with the whole Baker family. Tara was not in them. Every Christmas, every family gathering, every milestone, Tara was absent. She never got to be a sister to my wife. She never held my infant daughter, beaming with pride as an aunt. She never cradled my twins when they were born. My oldest child has had to learn of her Aunt Tara through photographs and stories. She favors her. I mourn not only Tara, but everything that was stolen from us. Tara would have turned 49 last month. I have no doubt she would have pursued her dreams, achieved her goals. She would have married and had children. My beautiful nieces and nephews that I never got to meet. My mother's precious grandbabies, who now would be old enough to chase their own dreams and start their own families. An entire branch of our family tree was severed irreparably on that one day to satisfy one man's depravity. The last 25 years should have been full of life, laughter, and generations. But the pain doesn't end here today. Despite this verdict, the pain will continue. This summer, I will retire from the career that Tara inspired me to pursue. My family will fly out. We will celebrate. There will be pictures. Tara won't be in them. She won't be there. Tara's children won't be there. Tara's grandchildren won't be there. In fact, our dad, who died at the age of 59, due to the stress and grief of losing a child, will not be there. And he is but one of a list of family members who I am certain would still be alive today had it not been for the stress, grief, depression, and utter devastation caused 25 years ago. For many years, I wrestled with God over what happened. That struggle eventually and ultimately led me to a place of forgiveness. Long before I ever heard the name Edrick Faust, I chose to forgive him. Today, sitting in this courtroom face to face, I can honestly say, I have forgiven you. I harbor no hate in my heart. I've given that all to God. You will stand before him one day. I pray that before then, you will confess, you will repent, and you will seek for the forgiveness of Christ. He will grant it. Until then, I need nothing from you except this one thing, that you never hurt anyone else again. Your Honor, I leave that responsibility to the judicial system. Please ensure that Mr. Faust never has the opportunity to harm another person. Thank you, Your Honor.
Thank you. Mr. Cruz, anything from the defense?
In regards to this witness, no, ma'am.
All right. You may call your next witness, Mr. Yelman-Chili.
Meredith Schroeder, Your Honor.
Afternoon, Your Honor.
Good afternoon.
During these last few weeks, we, Tara's family and friends, and all who loved her, were forced to relive this nightmare. to face the darkest time of our lives once more, to face things that we have avoided for 25 years. We sat and watched in horror the sight of her lifeless body, discarded like trash amongst the debris. We sat here in this courthouse and watched Tara be victimized once more, watched social media legal pundits co-opt our family photos as their own and opine on who they thought Tara was. I've watched as people came to spectate, like a morbid kid poking at her and us like dead animals on the side of the road. For all those interested parties, I will tell you who Tara was. She was our North Star, our champion. She was kind. She was determined. She wasn't perfect, but she was close to it. She spent her short life lifting people up and wanted to dedicate her life to making people happy. Happy law was her dream, and she had carved out her path to achieve it, and no one hated her. On January 19th, 2001, Tara woke and began her day like any other. While that day will remain the darkest of our lives, it was nothing compared to what Tara endured. I cannot imagine the fear and anger she felt, how she fought telling herself this was not happening. While Tara was our everything, it wasn't enough for Faust. For the last 25 years, he has wreaked havoc on this community. Just 2 weeks after he ended Tara's life, he put a knife into a man's neck. He shattered another man's jaw over a parking space outside the 40 Watt. He savagely beat his wife on a cruise and then later pistol whipped her with her own gun. While we have sat here trying to maintain our composure, I've watched the defendant sleep through proceedings. I'm terribly sorry to have inconvenienced him, but you see, while he got to walk free for the last 25 years, he dealt Tara and all of us a life sentence. He stole from her, he stole from me, he stole from my children, and he stole from all of us. None of us
All
are the same
caps in the
people who
chat.
woke up on January 19th, 2001. Every day for the last 25 years, I have literally thought about my sister. I've wondered if her wild and tacky sister would have made her proud. I've mourned the friendship that we were building outside of sister. I've mourned the tone-deaf car karaoke sessions and the Friday night rom-coms. I've mourned the life lessons that she tried to teach me, but my dumb teenage brain couldn't understand. The guilt that I feel that I've lived an entire life that was denied her cannot be measured. I have prayed that I've been strong enough for her, that I've fought enough for her. I've prayed these last few weeks that I've done right by her. Today I stand here, channeling her strength to face the man convicted by a jury of his peers to this nightmare, to let him know that after today, I will endeavor to forget his face and his name, to never allow him to cross my thoughts again. After today, I will live my life remembering how Tara lived. My final request is that this honorable court ensure that he is put somewhere where he finally ends his reign of mayhem. Thank you.
Thank you. Anything from the defense, Mr. Cruz?
Only to make 2 corrections, Your Honor. In regards to pistol whipping his wife, that is nothing that occurred or was evidence in this case.
I'll let you say that when it's your turn, but in terms of any questions you have for the
No,
witness.
absolutely
All right,
not.
thank you,
Then
sir.
why-
You may
why
call your next
ask if he
witness.
has-
Kevin Baker.
Good afternoon, Your Honor.
Good afternoon.
Of course, indulgence as I get my paperwork here. It's maybe one of the most difficult things I've ever had to do. Your Honor, my name is Kevin Baker. I'm Tara's youngest brother, who she affectionately called her baby darling. There's a 12-year age gap between the two of us, so I wouldn't see her as much as a big sister as I would see her as a motherly figure. Over the past several days, I have sat in this room and listened to people argue over semantics while thinking that my Tara, beloved sister, cuddle buddy and protector is gone. We're arguing over a Super Bowl and a World Series. Well, I can't tell you who won that game, but I can tell you every detail that happened that day. My earliest memories of Tara and I were singing Beatles songs and Elvis songs and having a dance party in the living room. We watched old movies like Wizard of Oz and the Braves game on TV as we would cheer on her boys to victory. I even told her as a young boy I was going to play baseball and I was going to be just like Chipper Jones, who she adored so much. She would sit there as I would tell her that, and she would smile and say, you could do whatever you wanted to do as long as you put enough effort into it. To help me sleep, she would tell me Bible stories and hold me close when I was scared of the dark or when things would go bump in the night. Everywhere Tara lived, she invited me to stay at her house. From her dorm at Georgia College to the 80 Pie house, I was always welcome, where most college girls would think having a 9 or 10-year-old little brother following them around a college campus would be annoying and maybe even a bit embarrassing. But she saw it as an opportunity to connect and show me how doing well in school can benefit you. I remember the last time I saw her. It was towards the end of Christmas holiday. Adam was home, and she thought how great it would be to have a siblings' day out. She took us out, myself, Adam, and Meredith, to Chick-fil-A for lunch. We laughed, we carried on, and had a great time as a family. It was probably my last true happy memory as a child. She said goodbye to me in the driveway. She bent down on one knee and gave me the warmest hug and a white turtleneck sweater and a brown leather jacket and a kiss on the cheek. She told me to do my best in school as a new school year would be starting. In a few weeks, she would be back to visit with just me. She planned to come home and visit with me and go to my baseball game. I started that next school year with just the focus on school and sports. Then came Friday, January 19th, 2001. I was taken out of school, oblivious to what was happening at the time. My parents were in a panic and dropped me off at my grandparents', who would soon drive me up to Athens. But before we made our way to Athens, I asked my grandparents if it would be okay to get something to give to Tara as a gift. My grandparents, already knowing what was happening in the situation, couldn't bear to be the ones to give me the news. So they took me to a Hobby Lobby. I got a dolphin figurine and I made it for her, not knowing that she would never receive it. I arrived at the Holiday Inn right down the road from here. As a child of only 11, I was given the news by my late father that there was a fire at Tara's house. My immediate response was, is she in the hospital? Tell me she's okay. My dad stood there, choking back tears, saying, no, buddy, she didn't make it. She's gone. At that moment, my childhood innocence was destroyed. It would be shadowed by grief and running around this college campus with flyers asking who killed my sister, asking questions, not knowing anything other than she was gone. Learning words that no elementary school kid should ever have to learn or know happened to his big sister. Words such as rape, stabbing, arson, and murder. Kids at school would say, we're sorry for your loss. I was only thinking to myself, I didn't lose her. She was stolen from me. Where most kids would come home to a warm house full of happiness, I came home to a house despite my parents' best efforts to create the best environment possible. It felt more like a mausoleum than a warm home. Unlike my siblings, I went through the majority of my life from childhood, teenage, and adult phases without Tara. Unable to ask her, am I doing okay? Is this what I should be doing in school or in life? Would you be proud of the man your baby brother has become? I strived to be just like her throughout my childhood. When I received awards, graduated high school, and graduated college, Tara was not there. When my father died, which this murder took years off of his life due to stress, instead of Tara holding me while giving me the news of my father's passing, I fell to my knees in a hospital parking lot at midnight alone to collect myself and be strong for my mother, who was already in the ER room waiting for me to arrive. I found love and married, and instead of a family being in the front row, I had 2 empty chairs with 2 white roses for both my father and Tara, who would have been there if the situations had been different. As this trial goes on, I have read and seen the absolute best and the absolute worst of people in both this courtroom and outside who seek to turn a sensitive matter into a circus of calamity and pandemonium for their own entertainment, for likes on their social media pages, all the while seeing how this trial has opened up old wounds and exposed horrible memories. I have heard how this man is sitting here fighting for his life. Well, it makes me think about something about that morning. Did Tara have a chance to fight for her life? Who was there at the moment when she needed someone the most? No one, because she was scared and she died alone. Your Honor, I've listened to details for the first time that I've never been told about this case, not because the case was not thoroughly investigated, but because of the horrific and gruesome facts that my family tried to shield from me due to the age at the time. Your Honor, when that verdict was read, the person that's sitting here in that pew that day is not the 36-year-old man that stands before you right now. It was that 11-year-old boy who brought back all that pain and loneliness of being in that hotel room knowing that his sister had just been killed. As a father of a young girl, I dread for the day that I will have to give the tale to my daughter of her Aunt Tara, not for being the loving aunt who would have loved her so much or strived for greatness, but as a cautionary story of safety, because someone thought that they could play God and decide who should live and who doesn't. I've taken my grief and I've used it as a career to help others during their time of loss and guide them through their grieving process. It gives me peace to know that none of these families that I will undoubtedly have to help in the future will not be caused by this man's reign of terror in this community. I pray that there will not be another family in this community that will have to deal with the same pain and sorrow and cruelty that we have had to deal with over these past 25 years. This is not the final chapter of Tara's story, because once this case is concluded and her story will live on in everyone who ever knew her and everyone who ever loved her, despite this man's best efforts to destroy her legacy and destroy her body, she will endure in our hearts forever. For those who are in this courtroom or maybe watching at home, I ask you this: will you remember her? Because she would remember you. Thank you, Your Honor, for your time.
Thank you. Anything from the defense, Mr. Cruz, of this witness?
No, ma'am.
All right, thank you. You may call your next witness.
Your Honor, we don't have any other witnesses. We're ready to make our recommendation at this time.
You may proceed.
Thank you, Your Honor. I cannot offer anything more important or more impactful than what Tara's family has already said, and I will not try. The court has heard the evidence in this case and all its brutality and depravity. It's horrific, even in the context of other murder cases. The state's recommendation in this case is as follows. On count 1, a sentence of life imprisonment. On counts 2 through 5, vacated. Count 7 would be 30 years confinement concurrent with count 1. Count 8 would be life consecutive to count 1. Count 9 would merge with count 1. Count 10 would be 30 years consecutive to counts 1 and 7 while being concurrent with count 8. Count 6 would be 20 years consecutive to counts 8 and 10. Count 11 would be 20 years consecutive to count 6. And count 12 would be 5 years consecutive to count 11. The total sentence would be 2 consecutive life sentences plus 45 years of confinement with 60 years of non-parolable concurrent confinement with those 2 life sentences. That's the state's recommendation, Your Honor.
All right, Mr. Yeoman, you went through that very quickly, so I'm actually going to ask you to go through it slowly so I take down what you say, and I will do the same, of course, for Mr. Cruz. If you'll do it a little bit slower for the court, I want to make sure I know what you are asking for, and then I'll do the same for Mr. Cruz.
Yes,
So
Judge.
start with count 1.
I will, and just
What?
for an overall, again, in total, we're getting
When
to
are we gonna
2
do this again?
consecutive life sentences plus 45 years of confinement with 60 years of non-parolable confinement concurrent with those 2 life sentences. And the way that we structured that was in count 1 life, counts 2 through 5 vacated, count 7, 30 years concurrent with count 1. Count 8 is life consecutive to count 1. Count 9, the aggravated assault, merges with count 1. Count 10 will be 30 years consecutive to counts 1 and 7 and concurrent with count 8. Count 6 would be 20 years consecutive to counts 8 and 10. Count 11 would be 20 years consecutive to count 6. And count 12 would be 5 years consecutive to count 11.
Thank you.
Thank you.
Anything else from the state?
No, Your Honor.
All right, thank you. Mr. Cruz.
Would you like us to start with mitigation before we get into sentencing?
Yes, certainly you can. If you are presenting witnesses, this would be the time to do so.
All right, thank you.
Thank you.
I had a lot of inquiries, if I may. If you're here to testify on Mr. Faust's behalf,
Oh.
can you raise your hand for me? All right, you all come up to the front row.
Also, big thank you. Shaboogies and Gloria both became members. Thank
Mr.
you,
Terrell, can you
guys.
help with the podium here? And then maybe we'll put a microphone, put it in between the tables. That would be very helpful. Thank you.
Your Honor, the first witness that we have is Miss Kinsey Faust.
Good afternoon. How you doing?
Good afternoon.
My name is Edrick Faust, and I'm speaking on behalf of my cousin, brother, Edrick Lamont Faust. And the picture that being painted as a monster, he's no monster. He's a human being. He has family that loves him and care for him. With all this, I want justice to be served, and just to be served the correct and right way. And all has been said and presented throughout the court system. I've been here day one, ever since Mr. Faust got arrested back in 2023, whenever it was. Like I say to this day, I want the Baker family to get justice. And I feel that justice was not served. And I feel that they're painting a picture of Mr. Faust like he's a monster. He's no monster. He has family, grandkids, kids, and all. And he has lost people also. My father, which is his uncle, which helped raise him. And I know my father raised me, and my father did not raise no animal, nor monster. And I ask you, Lisa, today, as you get ready to sentence Mr. Faust, to really look at the justice and the way things should be laid out. Because Mr. Faust, my cousin, I love him. My brother, we raised in the same house, like I keep saying. He's no monster. He's a human being. And things that happen to Tara, I am a female too. And I hate all of that. But I would like for justice to be served, and to be served the correct and right way.
Thank you. Ms. Gielman-Chile, anything from the state?
I don't have any questions, Your Honor.
You may call your next witness.
Your Honor, next we have Mr. Bryson Shields.
How you doing, Miss Lisa Lott?
Good afternoon.
I know E. I used to walk hard with him.
You'll pull that microphone
I'm
out.
sorry. I used while cars were eating, and like, and last witness, he's not no monster, man. And I'm sorry for what happened, but justice one served here, so that's all.
Thank you. Mr. Yelman-Chile, anything from the state?
No, Your Honor.
You may call your next witness, Mr. Cruz.
And I'd like to make a statement for on behalf of Mr. Faust. I know it's unique for the attorney to do so.
Go ahead, sir.
But Your Honor, you're aware that obviously our system is a system of laws, and once the jury renders a verdict, regardless if we agree with it or disagree with it, that's the law we follow. That's the procedure we follow. I would ask the Honorable Court to consider in its sentencing, and we know what the mandatory sentencing is in this case, but we would ask the Honorable Court to consider things that took place in this case. As the Honorable Court is aware, and obviously we don't relitigate issues, Mr. Faust didn't have opportunity to explain his DNA. Mr. Faust didn't have opportunity to argue consent. There were things, and throughout this trial, I spoke the truth this entire trial. Not one time did a dishonest statement come out of my mouth. But as I advised the Honorable Court, I've reviewed every piece of discovery in this case. And this case is a true tragedy. The very first time I stepped in this courtroom, Your Honor, I said in order to get justice for my client, I would have to get it for the Baker family. And obviously I failed at that. The jury decided otherwise. But Your Honor, I presented the evidence that I could present to the Honorable Court, to the jury as well. I am aware of the mandatory sentencing schemes, but I do know the Honorable Court at the end of this and upon sentencing typically gives its own proffer or statement to the defendant in regards to the Honorable Court's thoughts and the reason it's given the sentence that it is giving. I would ask the Honorable Court if it would consider this is a case of very unique circumstances. And obviously, the evidence that we presented again, the jury, as the finder of fact, found that our theory was not the truth. But I would just ask the Honorable Court when it renders its sentence to give the lesser on the lesser end, even though it's mandatory, but also in regards to the Honorable Court's statements to the defendant or Mr. Faust, which will come. I just ask the Honorable Court to keep everything in mind because Your Honor is aware of a lot more than I was able to present to the jury. And that's all I'd like to say to the Honorable Court. To the Baker family, this is a heartbreaking case. And as an advocate in this case, no one, the state and I, we disagree completely, but no one would ever say that this wasn't a tragedy. And I give my heartfelt, and I mean my heartfelt from the bottom of my heart, my heart goes out to you all and what you've been through. But Your Honor, I just ask you to consider that when it comes to your statement to Mr. Faust at the time of sentencing. Thank you.
Thank you, Mr. Cruz. Do you have any specifics with regard to counts 1 through 12 you'd like for the court to consider?
I do. My other two witnesses just arrived, Your Honor.
All right. You may present your witnesses, sir.
Be buying time.
Hey, my name is Katrina Faust.
Good afternoon.
Edrick Faust isn't a monster. He is a very lovely, funny, and hard-working person. Edrick will always be my cousin, my brother, and I ask God to protect him. I pray to God to give him strength every day and to keep his smile together. And his family will keep fighting for justice for him. Edrick Faust isn't the killer. He was accused as the killer, but he isn't the killer. And he also have a family that love him. And we're gonna keep fighting for justice for him as long as it take. And I'm sorry for the Baker family. And I'm sorry for my family had to keep grieving over this. Because it's been very hard for the Faust family too.
Thank you. Anything from the state, Mr. Yelman-Chile?
No, Your Honor.
You may call your next witness.
My name is Shonda Smith, and I would like to speak in reference to my cousin. I'm his first cousin, Edrick Faust. And I would like to say, Your Honor, my name is Shonda Smith. I stand before you today on behalf of my cousin, Edrick Faust. This is an incredible, difficult moment for our family. We are watching someone we love face sentences while firmly believing in our hearts that he is an innocent man and he has been wrongly convicted. Edrick is more than what has been presented in this courtroom. He is a son, a father, a cousin, a brother, a man of faith who has always been a source of support in our family. This man, he knows he's kind, he's compassionate, and he's deeply valued by those who truly know him. As a family rooted as our family rooted in faith, we believe in justice, but we also believe in mercy, grace, compassion, and the truth. God sees what we cannot see. God knows what we do not know. We humbly ask, as you determine the sentence, we consider his character, his strong support system that stands behind him. And I hope that this still remains in his future, if you could see his future as a loving, bright, intelligent man. Thank you for allowing me to speak. As I do love my cousin, I hope the Baker family finds justice, because this is not it. Thank you.
Thank you. Anything from the state, Mr. Yalamanchili?
No, Your Honor.
Mr. Cruz, any other witnesses?
No, ma'am, just discussion regarding
All right.
One more, Your Honor.
Go ahead, sir.
Good afternoon. My name is Tijuana DuBose.
Good afternoon.
I stand here today heartbroken, not just for Edrick, but for the Baker family. I have witnessed this for the last couple of years, and it's very heartbreaking. I'm sorry what has happened, but I just ask that you guys just look at my cousin as not being a murderer, because he's not. I understand that something did happen, but he wasn't the one that did it. I understand the Baker family would like to have peace and justice for what has happened to their daughter, but at the same time, you have the wrong guy. If I wasn't here myself, if someone told me what happened, I would say, this is not true. But I witnessed everything, and the things that I witnessed, I can say everything was wrong. Everything was done wrong here. I understand people had a job to do, and they want to protect themselves and their job and their family. But at the same time, it's two families that did not get justice. Edrick Faust family did not get justice, and the Baker family still don't have justice. So I just ask that God continue to step in, to guide us and lead us and direct us to the right person that did do this. But as you guys do what you have to do, you have the wrong guy. And I stand here today and I firmly agree on what I say. I'm the first cousin of Edrick Faust. We grew up together. I knew him. I'm 48 years old. We're just a couple of years of difference. But I've been here and I know the things that Edrick done. Our grandmother has been in our lives, and Edrick is a good person, but I'm not going to say everything he has done in his life has been good, because everything I've done has not been good. But at the same time, I don't feel like you should get punished for something that you didn't do. So I just ask you guys to just do what you have to do, but at the same time, know that God has the last word. I love you.
Thank you. Anything, Mr. Yalamanchili, from the state?
No, Your Honor.
Anything else, Mr. Cruz, in terms of witnesses?
No, ma'am.
All right. And anything else you'd like to tell the court with regard to counts 1 through 12, just
Yes,
as the
ma'am.
state did? Go ahead.
Yes, ma'am. Your Honor, I ask the Honorable Court to exercise its discretion. I understand in count 1, malice murder, the jury found Mr. Faust guilty of malice murder, and the Honorable Court, the only option the Honorable Court has is life with or life without parole. We would ask the Honorable Court to, in regards to count 1, for the lesser sentence, which is life, the lesser sentence, which is life with parole, in regards to count 1. Counts 2 through 5, those vacate as a matter of law. Count 6, our request is a 1-year sentence on the burglary, Your Honor, and as the Honorable Court is aware, and I stated before, our system is a system of laws, and we have to respect the jury's verdict. The reason I'm asking for 1 year on the burglary count, Your Honor, is based on evidence that the Honorable Court heard, which is the state providing to the jury that they couldn't show that Mr. Faust or how Mr. Faust got into the home. The Honorable Court could weigh the evidence in regards to the burglary charge. The Honorable Court is aware, and the Honorable Court can make a decision as to whether or not the evidence was overwhelming that Mr. Faust broke into Ms. Baker's home. So that's why we're asking for 1 year on the burglary count to be served concurrent. And that's count 6. Count 7 in regards to aggravated sodomy, and that was the oral sodomy. The Honorable Court's discretion is only from 25 years to life. If the Honorable Court issues a sentence of 25 years, I believe the statute requires that the remaining portion, if I'm not mistaken, is remainder of probation for life, if I'm not mistaken. So I'm asking the Honorable Court in regards to the aggravated sodomy oral for the lesser sentence in regards to the court's discretion, which is 25 years. I would ask that that sentence is concurrent to count 1. And if I didn't state it with count 6, I'm also asking the 1 year is concurrent to count 1. In regards to count 8, Your Honor, I believe count 8 and count 10 merge based on the language of the indictment. The language of the indictment provides that the basis for the rape in court's indulgence the indictment specifically alleges that Mr. Faust had carnal knowledge of Ms. Baker. However, when it comes to aggravated sodomy, which is count 10, which is the anal charge of aggravated sodomy, carnal knowledge includes anal sex. His sexual organ entering Ms. Baker's sexual organ. So we would say that count 8 and count 10 merges. In regards to count 10 merging into count 8, Your Honor, the Honorable Court's discretion is only 25 years to life, similar to count 7. We would ask the Honorable Court to exercise its discretion and sentence on the lower end, the 25 years with probation for life. We would ask that that is concurrent to count 1. In regards to count 9, aggravated assault, the Honorable Court is aware that the sentencing range is 1 year to 20 years. We would again ask for the lower end of that range, which is the, no, please forgive me. Aggravated assault merges into count 1 by law. So please forgive me. Count 9 merges into count 1 by law. As I mentioned in count 10 merges into count 8. Count 11, arson, 1 through 20 years. We're asking that the Honorable Court exercise its discretion and sentence Mr. Faust to 1 year. Concurrent with count 1. And in regards to count 12, I believe the statute does not give the Honorable Court discretion in regards to the sentence being consecutive. And I believe it's a 5-year consecutive sentence to count 1. So the total sentence that we're asking for is life with parole plus 5 years, which is the mandatory minimum that the Honorable Court could sentence Mr. Faust to. As a significant piece of the mitigation, as I mentioned, Your Honor, is that I hope the Honorable Court takes into account the evidence that came out in this case. I do believe when Mr. Faust was initially arrested, it caused an uproar in Athens because a lot of people assumed that, hey, we've got the right person. It's just based on this new technology that the GBI had. But once we came into the courtroom, Your Honor, the jury, the Honorable Court, and we respect the jury's verdict, I'm not relitigating that, but the Honorable Court, in regards to mitigation, heard significant evidence that was never stated before in regards to Mr. Melton's involvement in this case, in this crime, which was rejected by the jury, which I acknowledge. But the Honorable Court is also aware of the rulings that were adverse to the defense, and I'm sure the Honorable Court says, hey, it was 412, it was 412, it was 412. I respect the court's ruling. I disagreed on the record. But, Your Honor, you could take everything that came into this case, all the information that came out in this courtroom, and you can make two choices. You can either say, hey, there were some questions in this case. By law, I'm required to sentence this way. I am going to use my discretion and sentence him to the lower end. It's still a life sentence, Your Honor. Or the Honorable Court could say, hey, I heard the information that came out in this case. I reject all of it, and I'm going to sentence him to what the state requested, which is the maximum sentence on everything. I am not from Athens. However, this case has caused a divide in Athens. Just like I witnessed, the Honorable Court had the opportunity to witness, this courtroom was split down, and I hate to even discuss it because it's a difficult topic to discuss, but the courtroom was split pretty much down racial lines. The Honorable Court made concerns and, had concerns and discussed social media with both counsel. I didn't look at social media until after a verdict was rendered in Mr. Faust's case, and the damage that this case has caused in the Athens community is mind-blowing. There's some people extremely upset. There's also some citizens that are extremely relieved. But, Your Honor, in your position, you have the power to send a message, whether that's I'm going to give Mr. Faust the absolute worst sentence he could get, or I'm going to take into account everything that came out in this trial, and I'm going to sentence him within the guidelines as required by law, but I am going to sentence him to the minimums, and that's what we would ask, Your Honor, and I thank you so much for your patience.
Thank you. Mr. Lomachelli, do you care to respond to the argument by counsel about merger of count 8 and count 10?
He launched.
Yes, Your Honor. I mean, count 8 and count 10 do not merge. The carnal knowledge is defined in the rape statute as penetration of the vagina by the penis, and it doesn't merge with aggravated sodomy. I know I don't think any of the ranges that Mr. Cruz gave were based on statutes as they existed in 2001. I think he's going off the statutes as they exist currently. I think it's incumbent upon the state in our role in the process to point out that given that it's a murder from 2001 and no notice of intent to seek death was filed, it's not a death penalty case. Mr. Faust can't be sentenced to life without parole. I believe the maximum is life because the statute was changed subsequent to when the crime was committed in 2001. So I do want to point that out. Also, as far as the 25 to life range, again, by our review of the statutes, that's not correct. On the rape, I believe it's 10 to 20 or life. And on the sodomy, I believe it is 10 to 30 or life. So I do just want to clear up those factors. I think that's a misstatement of the law. And I'm not going to respond to some of the other things that Mr. Cruz said. Obviously, the court knows what it ruled and didn't rule, but I don't think those are accurate statements of the way the proceedings were conducted.
Thank you. Anything further, Mr. Cruz, about the issue of merger?
Sure. If I could have a second to look at the statement, the law, and it should take maybe a minute, 2 minutes at most to look at the law in regards to what statute applies at the time of sentencing or the time of.
Go ahead.
Thank you.
Also, big thank you, Sunshine, for you. I didn't want to read these while they were doing the victim impact statements. I don't ever try to
The state is correct.
step on that
The
stuff.
statute at the time of sentencing. If I could have a second, Your Honor, to look at the statutes, I looked at the current law and applying the sentencing ranges. The Honorable Court would allow me to look at the statutes at the time of in 2001, if that's okay.
Okay. Thank you, Mr. Cruz. So, ladies and gentlemen, I'm going to adjourn. I'm going to consider both parties' arguments to the court. That'll give you time, Mr. Cruz, to look at the statutes. I'll be back on the bench shortly. I do want everyone in the courtroom to know that the Sheriff's Department is in charge of the courtroom. And if they ask you to remain seated while they allow other persons to enter or exit, they are allowed to do that. I'd certainly ask for your cooperation. They are in charge, again, of the courtroom. I'm going to be adjourned for just a little while. I'll be back on the bench. And Mr. Cruz, if you have anything else you'd like to add with regard to looking at the statutes at that time, you may do so.
Who are they going to let
Right,
leave
thank you.
first? Do we have to cordon off one half of the courtroom from another? Anywho, Sunshine for You says, I just can't, the lies and deceit of this court. Yeah, I really don't get why she was holding up the 10-2 filing and insisting it was the amended and that she had all of it, when it was said more than one time that there were really 3 different things. The discovery certificate, the first notice with the 3 cases, and then the amended notice, which the state had already said that they had recently filed. And the issue is that the notice should be given no later than 10 days before the start of trial. State's argument is that what we saw in the discovery certificate, where it was just the vague, like, aggravating factors, recidivist, and for impeachment purposes, we may rely on prior convictions. Defense's position was it needs to be more specific than that, and that notice that they do have on the docket no later than 10 days before trial only identified 3 cases. So we're asking that the state isn't allowed to include cases from before that weren't included in that notice. So I don't know what was going on with that. Nothing new. And just threw in the cuss jar. Thank you. You know, I understand. I think we need that. I think this is always tough to watch. For me, I disagree with the verdict. And I understand that sentencing has to move on regardless. So it's kind of, I don't know. It's a hard thing to describe. We have positive QB saying, I don't think the family cares. They just wanted a conviction. Judge Lott doesn't give a damn. 12 guilty charges. These jurors should be ashamed. I keep replaying that jury 4-person's voice in my head. That was a shaky voice reading those charges. And I keep playing that in my head. I do not think that the 4-person, I mean, maybe it was shaky because of regret or lack of certainty. Maybe it was shaky because she was nervous about reading the decision. I don't know. But I thought that voice shakiness was notable. It was it just stood out to me. I'm not sure if I think that the family just wanted a conviction. My thoughts on the family, no statement on the way they feel is how they feel. I thought it was a bit odd that they were able to speak on supposed prior bad acts that might not even be correctly attributed, let alone speak on that at all during a sentencing statement. But the idea of being upset about public access to courts, I think it's hypocritical. The family participated in helping with legislation. Calki Yalmancelli campaigned with this case, this cold case being a big part of his campaign. We have the Classic City Crime podcast that the family was working with, and that's their right to do that. But I at the same time, you can't think it's okay to speak your piece. And when you hear something that's different from your opinion, to just call that a circus. I just don't think that that's logical. I don't think that that's rational. It seems hypocritical to me. And I think trials should be transparent. And it's hard. Like, if you watch a trial and a trial is about a murder, a trial is about something bad, like, of course you're going to hear bad things. But I think the transparency is important. And I'm always going to opine on that, even though I don't judge victims on either side. I don't judge either family who spoke for either side. I don't judge their positions. I don't judge how they feel. So I think there's a chance that he didn't do this. I think there's a good chance that he didn't do this. And a separate question is, I don't think he had a fair trial. Should he have put up a DNA expert? I mean, the initial statement that we heard from Cruz, it kind of seems like he was, not when he was giving his argument for sentencing, but when he made the statement between the victim impact statements, between the witnesses. I feel like he was hinting at ineffective assistance of counsel, right? he mentioned not putting up a witness, and then he got into adverse rulings where he took an initiative to file something, and then there was a ruling that wasn't in his favor. But I think he hinted at an IAC claim for appeal. And the question over and over, it's honestly a bit nauseating to see how did his DNA get inside the victim? I mean, we heard from the state's witnesses that there were at least two additional unidentified profiles on swab 2I. So how did that DNA get there? I really think we need to give a serious look at the way DNA comes into trials. We are amplifying DNA so much. The technology is changing. The DNA amplification is letting us see all sorts of trace DNA, touch DNA, transfer DNA. You know, if you don't believe that this case is that type of example, best believe there will be, and has probably already been, cases where somebody's DNA was somewhere that made them look bad, but they were not the person, and they were not even in the same location when the crime occurred. And again, take what I'm saying and think of it outside the context of this case and your personal feelings about what happened at this trial, and whether you think the person who was convicted is guilty or not. Yeah, and here, early contemporaneous testing in 2001, testing for semen was negative. Testing for partial semen was negative, and that was 2001 testing. So, and even though we heard another witness say, like, using the term sperm, she was questioned on that, and she had to correct herself and say, well, no, that's just the words that we use. So, Sirach, I can't answer that because there's opposing positions. So, defense's position, you know, they were only put on notice for three cases. And the state said, well, we said earlier in another the discovery certificate that we would rely on convictions for recidivist, for aggravation, and for impeachment. So we should be able to say anything now, even without having given specific notice, no later than 10 days before the start of trial. I mean, I just explained it, Behemoth, and you're not listening. So just because someone's DNA is present, I mean, there's several layers to consider. 1, a consent issue. 2, chain of custody issues. 3, input-output issues. 4, nobody can actually get into the algorithms of the specific software that was used here. 5, there's issues with Kiogen, the company Kiogen, which is the company that was being contracted for the equipment and testing kits that were being used in 2024 when these things were retested. What am I at, 6? There were additional unidentified profiles on swab 2I. I mean, if you just say the blanket phrase DNA doesn't lie, then what about those samples? And what about the anal swab? If DNA doesn't lie, then what about the DNA on the anal swab? I think we need to advance our thinking about the phrase DNA doesn't lie. It honestly is starting to seem intellectually lazy. And that's an encouragement to think. It's not me saying, how can people be so stupid? I don't think that's an appropriate position to take to anybody that's having a conversation. And that's really not what this chat's about. Yeah, and also DNA was not found in the apartment. And for what it's worth, going to the no hairs found there, the supposed witnesses that were described with different descriptions in a neighborhood where people were previously reporting seeing people walk through the neighborhood, those people weren't all Edrick Faust. Whoever they were, if one of them was Edrick Faust, the other person wasn't. Why weren't they wearing hoods, hats, or carrying any equipment that would help them not leave trace evidence behind? So Georgia is a death penalty state, but they didn't file notice that they had intent to pursue death penalty. So this just wasn't a death penalty case. Yeah, and what happened, like, why do we not get a sketch of the white guy that was seen running from the back area of the house around sometime at or before 7:45 that morning? Like, do you think that's the way can anyone seriously say that that's the way that an investigation should go? That we pick and choose who goes and sits with the sketch artist and who doesn't? When we all had those reports the same day? Let's do sketch artists of the individuals that are walking at a regular pace. One of them was wearing a bright orange t-shirt. Nobody was wearing a hood and hat. And let's not have the person who was running through the backyard, not on the sidewalk, not at a normal pace. Let's not have someone sketch that person. Let's not show them photos. That doesn't seem like a good investigation. That's not how I'd want an investigation to go for any case. An investigation where we're saying we canvass the neighborhood, but we don't go knock on the door at 350 Cooper Road. Did we really canvass the neighborhood? It's just doesn't seem like a good investigation. I mean, the missing window screen is a side saga on its own. Why do we have a missing window screen? And I do understand that there were some other individuals that were spoken to that we didn't get to hear about at this trial because the third-party culprit defense specifically pointed at Chris Melton. But we also heard that Chris Melton was only spoken to 4 times before GBI came into the picture and then needed to go talk with Chris Melton on May 5th of 2024. 2 of those interviews seemed to be 26 minutes and like 48 minutes in length. That really doesn't seem like all that much. Even if Chris was never a person of interest, I feel like there should be so much that he could help you understand that you would need to talk to him more than that just to help figure out other potential leads, other potential patterns of behavior, other things that might have been off recently. So I don't know. And then you have 25 years removed. I mean, I have questions. How do you defend yourself if you're told that your DNA was found somewhere 25 years ago? And if you weren't the type of person, 25 years ago meaning this isn't the era of meeting people online and then going out to meet with them after meeting them on a dating app or something, or on Facebook, or being in a friend circle where you could look somebody up before you go out with them. This would be in the era where maybe you write your phone number down on paper still. You're not just pulling out your phone and texting to exchange numbers right there, adding each other on Snapchat. There is no type of paper trail like that to have been written then, contemporaneously. Let alone for you to only think of and know that you would need 25 years later to then have to think of and go back and find a way to procure. The little bit that they were able to go back and try to look at, the landline records, can't come in because the company is out of business. How do you defend yourself? If you're the type of person that was out somewhere in the same place as somebody one night, how do you go back and prove it? Probably can't go back 25 years and secure surveillance video if whatever place may have had a video. I don't know. And I want to be clear, like, all of the issues I'm taking with the investigation, I would imagine that if Chris Melton or any of the other people that were suspected through the years, or if they identify the currently unidentified profiles on Swab2i and say, well, oh, your DNA was there too, you were in this house, that blah, 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 blah. Any of those individuals, if they were on trial, I would imagine their attorneys would and should point to the same issues with the investigation. And I like to think, hopefully investigations are a bit better now in 2025, 2026, but, sometimes it doesn't seem that way. Doesn't seem that way. Yeah, the age of ASL, AIM Instant Messenger, the OG RuneScape. Yeah, yep. Definitely hard when it's long ago, and those phone records that they had can't come in because whatever the company was it Bell South or something? Doesn't exist anymore. Yeah, and I think this is valid, I think it's always a huge mistake for the defense to not put on a case, to leave them with nothing but the state's evidence. Because people will ask, well, why wouldn't you just say you're innocent? How could you say you didn't know somebody? And there's two major defenses to that. Hey, either explain how with new technology, which Jeremy Howell talks about in that interrogation video, new technology is so much advanced, it's so good it can detect anything. You put up someone that can explain trace evidence and also try to talk about likelihood ratios and how they don't mean it's like 1 in 87 octillion to 1 that this is the person identifying this specific person that did it. That's not how likelihood ratios work. Or you get up there and you explain how, hey, look, when I said those things during the interview, during that time in 2001 when I heard that story, I read an article in the paper, I didn't see a picture. So then it didn't cross my mind that it might have been someone that I was in the same place as. And the picture they showed me, I didn't recognize that either. And quite frankly, I've seen several different pictures of Tara. She doesn't look the same to me in different pictures. And to try to remember someone from a picture that you've never seen before when you're being shown 25 years later. And his first response was before they showed a picture to him. I don't understand why that's kind of a difficult thing for people to understand, why he might not know what they were talking about. He didn't have the context in front of him. Like, if you asked me to remember, like, who lived, I could probably tell you freshman year of college, the faces of, like, the girls that lived in the 5 rooms on my wing. I don't think I could tell you, I can't picture the faces of anybody that lived on the opposing wing, even though I walked and saw them all the time. And that's like a decade and change ago. Like, it's not 25 years ago. So, and also a big thank you here. We have Allie giving out 5 memberships. That's super nice. And good to see you, Allie. I hope you're doing well. Let's get some shout outs for Allie in the chat. Always super nice. We have some channel emojis here to make trials fun. They change up when we go to different trials, but right now there is one for Yalmicelli and one for Cruz. We added the swear jar for this trial as well. And this is also the trial where we brought the hand in. If you're wondering why we have a creepy hand in the channel emojis, it's the portrait that's behind the witness stand. Anytime a witness was on the stand in this trial, they'd be sitting in a chair right here, and there'd be a hand just lingering over their head there. Yeah, I think tale as old as time, right? Maddie's like, this is why you don't talk to cops even on illegal stops. I mean, yeah, gotta get an accordion. Hold on, there's an accordion in the chat. Give us some background music. I think Cruz wanted to put on a case. He had witnesses that they were queuing up that very day, the same day he decided to rest. And it was after the judge sustained each of the motions in limine that the state raised. But remember, he was setting up having the WebEx or the Zoom, I forget what software they were using, to make sure his witnesses could appear. But all of those motions were granted for the state. So, I don't know. This is gross, but I don't know. I'm gonna read this as a reminder to think twice before you put things in your mouth. So Angelica's like, what if she used an ink pen that Faust used? Think about that though. Again, remove yourself from this case, these situations. That's how things can transfer. And by things, I don't just mean DNA, I also mean germs. So, oh man. It's like that. It can be like that. Let's see. Grody. Yeah, Butterfly Lover, that day, it kind of stumped me because it was just it was a surprise because that morning he was ready to put up his witnesses. They were planning for the time, but then they went through motions, and I believe they handled one of the arguments outside presence of the broadcast. So I think we heard 2 of them were granted for the state, and then they did something that we couldn't hear. And then it was just nope, we're going to rest. So, well, what's interesting about the 500 feet thing is they didn't canvass that house. So again, it goes back to a poor investigation. They didn't canvass the house that was right there. That would have been directly across. If someone was running from the back of the house through the grass, that house faces that outlet from where the grass was, in between the 2 rows of houses. Additionally, this incident that happened on February 8th, where the mugshot came from, which was a 2-week confrontation going on with someone that Faust knew with the stabbing, the address they used for him then, for his arrest, was a totally different address, not near Deer Park. So we heard a little bit of tension about that issue because it was known to law enforcement, and Cruz wanted to rely on that as hey, we can show that his address was somewhere else. Within 2 weeks, there's a record. There's a record that shows that he has a different address. And they wouldn't let him ask the detectives about it. So which one was it? Was he at 350 Cooper Road, or was he at the address that was on the arrest slip for February 8th? I don't think we heard anything about shoe printing. And to be honest, I think it looked like there was carpet in most of, the picture where we saw, the living room area, the little table. I think that was carpeted. And then even if the kitchen floor was tiled, I imagine the fire hoses were probably like that would be the pathway where I know they went right to the room and the flames were coming out of the bedroom door, but I'd imagine they hosed down that tiled area. So see, but I think this shows that you like don't understand that people don't live life the same way as like what's in your mind and your experience is not everybody else's. Thirsty Thursday in a college town does not mean only college students are out. Like, I used to work in nightlife. We brought together college students and the town. You know, from colleges that were like within the surrounding like 30 to 45-minute radius. So multiple colleges coming into the city to go out. And it wasn't even just Thursdays. It would be Tuesdays and Monday events too, let alone Friday, Saturdays, and Sundays. So, yeah. College age going out, you do end up with people that aren't enrolled in the same school as you. They were the same age group. And I don't know, the idea, the way you're characterizing this seems like it's prejudicial. And I'd encourage you to think about that a little bit. Yeah, and I think the idea they lost once they never explained how his DNA got on her. I mean, we know that the jury did ask to look at that DNA report. So, good point. The third party culprit wasn't enrolled either. I mean, yep, you can live in the same town and not know everyone. Well, like I was saying, like I don't specifically remember the girls I lived like the opposite wing. And when I say opposite wing, I mean like it was like a wing of like 5 or 6 dorm rooms, and then there was like the janitors and then the like restroom facilities, and then another wing of 5 or 6. But you had to walk through, like we were on the corner, we had to walk past the other wing constantly, and like the common area, anybody from that area would go to that common area. I don't really remember those other girls. Like I just don't remember their faces. Don't remember their faces. Same town, we did not go to the same places to eat. We didn't go to the same places on Friday night. We would go to the library till 10 o'clock, and then we'd go out wherever we were going, and we'd get pizza afterwards, and other people had different routines. Yeah, gross. Grody Ted. Kind of relatable. Living in a village of 650 people and don't know 640 of them. Chicken wings is chicken wings. I think that's up for debate, isn't it? Like the boneless wings thing with there's 2 different boneless wings lawsuits. There's the one where the guy found a bone chip in a boneless wing and wanted to sue. And I think that was Ohio, and the Supreme Court, or at least a court of appeals, was like, well, you should have a reasonable expectation that an animal product might have bone in it, even if it's called boneless. And then there's the boneless Wild Wings, Buffalo Wild Wings boneless wing lawsuit, where I believe the complaint is that they're actually chicken nuggets and not literally a chicken wing that's been deboned. So I'm not sure if chicken wings are really chicken wings. Or maybe it's like a rectangle and square type of argument. Because boneless chicken wings, which are not the wing, can also be a wing. So see. Every boneless wing. Let's see. Buffalo Wild Wings lawsuit. Oh, we have a hilarious title. Oh, let me get this in a ad-free viewing. All right, so judge, lawsuit against Buffalo Wild Wings has no meat on its bones. An Illinois judge ruled that a Buffalo Wild Wings customer's lawsuit over the restaurant chain's boneless chicken has no meat on its bones. Eamon Halim sued Buffalo Wild Wings in 2023, alleging that its use of the term boneless wings is deceptive because the menu item contains chicken breast meat. According to court documents, Halim ordered the boneless wings at an Illinois location in January 2023, expecting to receive wings that were deboned. Had he known... You couldn't pay me to take, like, unless I'm eating the wings. Can you imagine deboning chicken wings before you cook them for the sake of preparing them that way? No way. Had he known he was eating breast meat, Halim would have refused to buy the product or paid less, the documents say. Halim sought monetary damages. On Tuesday, Judge John Tharp Jr. of the U.S. District Court for the Northern District of Illinois rejected Halim's claims, riffing in his opinion that the plaintiff did not drum... Oh gosh. Flats or drums debate up enough facts to support his claim. Tharp said the term boneless wings is not deceptive, but rather a fanciful name. He wrote that words can have multiple meanings, using the example of buffalo wing, which he said refers to the type of sauce on the wing. Gotta do the classic Franks, or Duff's Wings if you are, from New York. Anchor Bar, which he said refers to the type of sauce on the wing rather than indicating it is made of buffalo meat. Well, good point. A reasonable consumer would not think that Buffalo Wild Wings boneless wings were truly deboned chicken wings, reconstituted into some sort of Frankenwing. Tharp also compared the item to cauliflower wings, another product sold at Buffalo Wild Wings, writing that a reasonable person would not believe this dish is made from wing meat. Later in his opinion, Tharp stated that boneless wings is a common term that has been in use for over 2 decades and is familiar to customers. Buffalo Wild Wings likewise said that a reasonable consumer would not be misled by the term boneless wings, and that context clues make it clear that the product cannot be made of wing meat, the opinion says. The restaurant chain celebrated Tharp's decision by offering a buy one, get one boneless wing deal on Thursday. I think they always do that, by the way. I think Buffalo Wild Wings Thursday is their BOGO day. But anyway, maybe they made it a celebratory thing that day. Oh, they did a social media post. All right, I see action in the court. Let's get back over there. Continue the drums versus flats versus boneless wing nugget debate in the chat. Well, I would choose ranch, don't hate me, but yes on the butter and bottle of Frank's. When I make wings, it is a process. I go through an intricate process, like SpongeBob cooking a Krabby Patty. Like, I brine them, poach them in the brine real quick, then lay them out on a rack to air dry in a cooler in a fridge. So that way the skin's dry. And then I fry them. That way they're cooked all the way through and still juicy on the inside, but the skin is able to crisp up. That's why you gotta, like, put them on the rack to dry them. And then I toss them in the sauce. Takes some time. Takes some time. Everybody wants wings now. What do you guys think about cauliflower wings? Have you guys tried those? Because the pictures I've seen, they don't look fried. Do you fry those, or it is just like putting hot sauce on cauliflower? All right, back to serious stuff.
Yes, sir. Did you want to say something?
Yes, ma'am. I had an opportunity to look at the law. We withdraw the merger. I did look at the law from 2001 in regards to aggravated sodomy and rape. We withdraw the merger from that count. Count 1 was correct. You have the option of life or life without parole. Count 6 is correct. It's still 1 through 20 years. But we would change our request to count 7. The minimum is 10 years, so we'd ask for 10 years. And that's in regards to the aggravated sodomy. Count 8, rape, is 10 to 20 or life. We would ask that the Honorable Court exercise its discretion and sentence Mr. Faust to the 10 years, and count 10 as well as the 10 through 30. We would ask the Honorable Court to exercise its discretion and sentence Mr. Faust to the 10 years. Thank you, Your Honor.
Thank you. All right, counsel. I'm actually going to give you both, all three of you, 15 minutes to do some homework, and here's why. The state has asked the court to sentence this defendant to the maximums.
More homework.
And the defense has asked the court not to do that. And of course, the 2001 law is not something that is readily accessible and readily available, and it is a little bit different than the law now. The question I have for both counsel is, pursuant to the rape statute and also to 1710 6.1, what your position is on whether the rape charge carries the possibility of life without the possibility of parole. I'm doing some research based on the state's request and the defense's request as to whether in 2001 that was a possibility. 1710 6.1 is the violent felony, the statute that applies to violent felonies. And I think there is an understanding among cases that happened back then that the count of rape could carry with it the possibility of life without the possibility of parole. I'm going to ask the three of you to look at that. I'll give you 15 minutes. I'm going to go finish my research. I'm asking you to do that because both parties have asked for opposite ends of the sentencing structure. State has asked for the maximum, which they are contending is life on that charge, on the rape charge. The defense is asking, of course, for that not to be considered. And so because of that, I'm going to ask you all to look at that. Yes, sir. Anything before I leave the bench? All right, I'll be back in 15 minutes. Thank you.
Kind of sucks that the prior versions aren't readily accessible. I think that's what she'd said. Didn't she say she was going to do some research before the break that we were just waiting on before we just came back? So I feel like maybe she tried to look and couldn't find it. So, dang. Are we going back to chicken wings? Are we going back to chicken wings? Kind of another thing, right? Like if we're going to be tackling cold cases, like we definitely want to make sure we're aware of if new legislation came out or legislation was amended, is it applied retroactively? Or what are the conditions for whatever the change is to apply? So I'm in Florida, if you guys didn't know. One thing that's been interesting to watch in Florida is like this ping pong that seems to be going back and forth between legislation and case law about death penalty, capital punishment sentencing. You know, we've switched back and forth for only 8 of the 12 required for a jury to find that someone could be sentenced to death under capital punishment here in Florida. And then if that's met, then the judge can consider it. If the jury says no, then the judge can't consider it. But the judge still has to agree to sentence someone to death. It's not just like the jury, their vote goes. But at times it's required a unanimous jury decision. And there are cases that are caught in these appeals and retrials. And then the sentencing, it's like, well, the sentencing happened in this time period when only 8 out of 12 needed to say, yes, we think all of the factors are satisfied. Now it's supposed to be unanimous. So we need to redo the trial because the sentencing is at issue. And it's just like such a mess down here in Florida. And they change it all the time. There's been multiple changes in the last 2.5 decades or so. And it's just like an appellate nightmare. Yeah, and that's what I think would be interesting though, Aaron, is like, I don't know how necessary it's or how common it's been, but to be able to look up quickly and just ensure that, hey, we need to see in this 2001 what it said in 2001, and maybe it was amended and changed in 2004. Like, what was that change? Like a quick reference, I think, is going to be more important than ever before. If we're going to be prosecuting more things from earlier time periods. Some of us like appellate nightmares. Oh, come do some pro hoc vice down in Florida, Hal. It says someone call Brian Steele. He probably has this memorized. Or Bruce Harvey. Call Bruce Harvey. All right, so it should only be 15 seconds. All right, can you beat... Judge Lott is already like 15 minutes deep into the research, or however long her break was. But the parties here just started their 15-minute research. So can you beat them, Hal? That's vague and ambiguous. What do you mean, Florida man? Just as a collective? Florida man is a class. Let's see. Yeah, I think this is exactly it. I think that's what she was researching and then couldn't find it, and so she wants both parties to do it. For the wings, just to close that story out, and guys, if you like stuff like this, I love reading stupid stuff like this. Usually we actually look at the complaints or the opinions. Let's see. Plaintiff's lawyers did not respond for requests, but they have an opportunity until March 20th to file an amended complaint. So the suit isn't completely gone. They have another opportunity. So the saga might continue. This might not be the end of the boneless wing debate. I think they might just stay late, but... Because why not? I mean, it's not like they have to hold a jury. So... What was the Ohio boneless wing with bone piece? This one wasn't as recent, though. Duplicate. Let me get rid of the ads. Boneless chicken wings can have bones, Ohio Supreme Court rules. Okay, and this was, let me see. This was July 26, 2024. A divided Ohio Supreme Court ruled Thursday, so it was not a unanimous decision, that a customer who ordered boneless chicken wings could have reasonably expected to find a piece of bone in his meal and guarded against swallowing it. In a 4-3 decision, must have been tense, the state's highest court ruled that the lower courts properly dismissed Michael Berkheimer's 2017 lawsuit against a restaurant and its chicken suppliers at the summary judgment phase. In 2016, Berkheimer, his wife, and a few friends dined at Wings on Brookwood in Hamilton, where he ordered boneless wings with Parmesan garlic sauce. Sorry to make you hungry. He said, Parmesan garlic sauce kind of sounds weird. I'm so used to saying garlic parm. He said he'd eaten his third wing when he felt a piece of meat go down the wrong pipe. He went to the restroom to try to clear his throat, but was unsuccessful. Well, that doesn't sound like you know that it's a bone. Over the next 3 days, he spiked a fever and had trouble eating. During a visit to the emergency room, a doctor discovered a thin chicken bone lodged in his esophagus. Ooh. measuring about 5 centimeters. That's very scary. Berkheimer sued Wings on Brookwood in 2017, though the case was dismissed by lower courts. In Thursday's ruling, the majority of the Ohio Supreme Court ultimately concluded that boneless wings refers to a cooking style and is not a guarantee that fragments of bones would not be present. A diner reading boneless wing on a menu would no more believe that the restaurant was warranting the absence of bones in the items than believe that the items were made from chicken wings, just as a person eating chicken fingers, that's a good point, would know that he had not been served fingers. Justice Joseph Dieters wrote for the majority. The dissenting justices called Dieters' reasoning utter jabberwocky. And said a jury should have been allowed to decide whether the restaurant was negligent in serving Berkheimer a piece of chicken that was advertised as boneless. And we have a quote here in dissent. Does anyone really believe that the parents in this country who feed their young children boneless wings or chicken tenders or chicken nuggets or chicken fingers expect bones to be in the chicken? Of course they don't. Justice Michael Donnelly wrote in dissent. When they read the word boneless, they think it means without bones, as do all sensible people. Oh my gosh, I want to see them argue with each other about this issue. Oh man. That is utter jabberwocky. Yeah, Coke Fairy, that seems like a solution there, like may contain bones or fragments, whatever, from processing, like that language that they would use. Ooh, Brooklyn, we did just get a Trader Joe's in the Vieira, of course, Vieira. If you heard earlier today when we were doing the Scott Spivey wrongful death lawsuit hearing stream, I was talking about, Vieira is like this like place, it's being developed on land that I don't think was zoned for development previously, but now they've been building it out rapidly. And they don't have their own police department. They have the sheriff's office cover like the jurisdiction of the whole town. But I think they just got a Trader Joe's out there. So we're finally getting all of these things that I hear about near me. Yeah, U.S. courts are nuts, but they're funny. They're funny. They'll argue about everything. EJF says, I only eat boneless wings because I hate the thought of bones in my food. I don't even cook things with bones. I love, like, just being able to process everything and cook it down and make, like, stews and bone broths. So, total opposite. But I would prepare stuff without the bone for you. If we had a dinner party, if we had potluck, I would prepare it boneless. And I'd be careful about preparing it. Did they order wings while they decided? They got wings for lunch that day. Clam chowder case? Hold on, that's confusing before I even find out what the lawsuit's about, because aren't there different types of clam chowder? Oh, I see a shirt on screen. Random piece of cat lore, but when I was like, I don't know, I can picture myself in our first house, so I was still little. But apparently my mom gave me Campbell's chicken noodle soup for lunch, and I complained. My mom had to tell me the story. I don't really remember it. But she was like, you complained that there was no chicken in it, and I guess I hand-wrote a letter. I hand-wrote a letter complaining to Campbell's, and they sent me a coupon book. I had a whole stack of coupons for Campbell's soup as a little kid. And then they came out with like one of those now 35% more chicken right after my letter. So I felt like I was effective. So it's another story my mom loves to tell. Okay, wait. So clam chowder lawsuit. Okay. There are a lot of lawsuits that don't seem to be specifically about clam chowder. Ew. Lawsuit claims bobby pins found in soup at popular Myrtle Beach seafood restaurant. Multiple bobby pins? Heck yeah, Changemaker. Okay, it's old. Okay. Yeah, it's probably... Ew. This is... Guys, what is going on that is gross? What are these... People also ask... One of the people also ask is it illegal to make clam chowder with tomatoes in Massachusetts? What do people be Googling? Oh my goodness. Botulism lawsuit for kettle cuisine clam chowder, gross. Is this the one you guys are talking about, though? The clam chowder lawsuit? Okay, wait. Okay, yeah, Webster. Okay, let's find, like, a regular, or I'll just search it. Alright, let's put this back on in case we miss anything. Let me find it. Webster. The Blue Ship Tea Room. I complained to the whole company. I think I got it out of my system because I'm not really the type to complain about things anymore. I'm not hungry. I didn't want to finish my food and just go. I have a concern that if I say my food isn't done right, that they'll remake it and someone might spit in it, so I don't even want to risk the chance. Alright, so Webster v. Blue Ship Tea Room. Dang. This is a throwback. 1964. So, let's see. The mere presence of a fishbone and chowder containing chunks of fish and potato eaten by a New Englander at a restaurant after stirring the chowder did not constitute a breach of the implied warranty of merchantability of the chowder. You can tell this is from 1964. Implied warranty of merchantability of the chowder by the proprietor of the restaurant under Section 2-314 of the Uniform Commercial Code, and did not render the proprietor liable on that ground to the customer for injuries received when the fishbone lodged in her throat. This is so interesting. Just the difference in vocabulary. So, Justice Reardon here is saying this is a case which by its nature evokes earnest study, not only of the law, but also of the culinary traditions of the Commonwealth, which bear so heavily upon its outcome. It is an action to recover damages for personal injury sustained by reason of breach of implied warranty of food served by the defendant in its restaurant. An auditor, whose findings of facts were not to be final, found for the plaintiff. On a retrial in the Superior Court before a judge and a jury, in which the plaintiff testified, the jury returned a verdict for her. The defendant is here on exceptions to the refusal of the judge: 1, to strike certain portions of the auditor's report; 2, to direct a verdict for the defendant; and 3, to allow the defendant's motion for the entry of a verdict in its favor under leave reserved. The jury could have found the following facts. On Saturday, April 25th, 1959, this is such a throwback, about 1 p.m., the plaintiff, accompanied by her sister and her aunt, entered the Blue Ship Tea Room operated by the defendant. The group was seated at a table and supplied with menus. The restaurant, which the plaintiff characterized as quaint, was located in Baston, on the 3rd floor of an old building on T Wharf, which overlooks the ocean. The plaintiff, who had been born and brought up in New England, a fact of some consequence, ordered clam chowder, because they're going to say you should be aware, ordered clam chowder and crab meat salad. Within a few minutes, she received tidings to the effect that there was no more clam chowder, whereupon she ordered a cup of fish chowder. Presently, there was set before her a small bowl of fish chowder. She had previously enjoyed a breakfast about 9 a.m., which had given her no difficulty. The fish chowder contained haddock, potatoes, milk, water, and seasoning. The chowder was milky in color and not clear. The haddock and potatoes were in chunks, also a fact of consequence. She agitated it a little with the spoon and observed that it was a fairly full bowl. It was hot when she got it, but she did not tip it with her spoon because it was hot, but stirred it in an up and under motion. She denied that she did this because she was looking for something, but it was rather because she wanted an even distribution of fish and potatoes. She started to eat it, alternating between the chowder and crackers which were on the table with some rolls. She ate about 3 or 4 spoonfuls and then stopped. She looked at the spoonfuls as she was eating. She saw equal parts of liquid, potato, and fish as she spooned into her mouth. She did not see anything unusual about it. After 3 or 4 spoonfuls, she was aware that something lodged in her throat because she couldn't swallow and couldn't clear her throat by gulping, and she could feel it. This misadventure led to 2 esophagoscopies at the Massachusetts General Hospital, in the second of which, on April 27, 1959, a fishbone was found and removed. The sequence of events produced injury to the plaintiff, which was not insubstantial. We must decide whether a fishbone lurking in a fish chowder, about the ingredients of which there is no other complaint, constitutes a breach of implied warranty under applicable provisions of the Uniform Commercial Code, the annotations to which are not helpful on this point. As the judge put it in his charge, was the fish chowder fit to be eaten and wholesome? Nobody is claiming that the fish itself wasn't wholesome, but the bone of contention here, I don't mean that for a pun, but was this fish bone a foreign substance that made the fish chowder unwholesome or not fit to be eaten? The plaintiff has vigorously reminded us of the high standards imposed by this court where the sale of food is involved, and has made reference to cases involving stones and beans, trichinae in pork, and I think that's like mostly gone right now. You don't have to worry about that like you used to have to worry. And to certain other cases here and elsewhere, serving to bolster her contention of breach of warranty. The defendant asserts that here was a native New Englander eating fish chowder in a quaint Boston dining place where she'd been before. That fish chowder, as it is served and enjoyed by New Englanders, is a hearty dish originally designed to satisfy the appetites of our seamen and fishermen. Awkward word to read in the context of this stream. That this court knows well that we are not talking of some insipid broth as is customarily served to convalescents. We are asked to rule in such fashion that no chef is forced to reduce the pieces of fish in the chowder to minuscule size in an effort to ascertain if they contained any pieces of bone. In so ruling, we are told, in the defendant's brief, the court will not only uphold its reputation for legal knowledge and acumen, but will, as loyal sons of Massachusetts, save our world-renowned fish chowder from degenerating into an insipid broth containing the mere essence of its former stature as a culinary masterpiece. Notwithstanding these passionate entreaties, we are bound to examine with detachment the nature of fish chowder and what might happen to it under varying interpretations of the Uniform Commercial Code. This is so dramatic. This is so dramatic. Chowder is an ancient dish, pre-existing even the appetites of our seamen and fishermen. It was perhaps the common ancestor of the more refined cream soups, purees, and bisques. Berletimer, the American Woman's Cookbook. Oh, that's where that's coming from. The word chowder comes from the French chaudière, meaning a cauldron or pot. Don't trust my pronunciation on that. In the fishing villages of Brittany, faire la chaudière means to supply a cauldron in which is cooked a mess of fish and biscuit with some savory condiments, a hodgepodge contributed by the fishermen themselves, each of whom, in return, receives his share of the prepared dish. The Brayton fishermen probably carried the custom to Newfoundland, long famous for its chowder, whence it is spread to Nova Scotia, New Brunswick, and New England. Our literature over the years abounds in references not only to the delights of the chowder, but also to its manufacture. A namesake of the plaintiff, Daniel Webster, had a recipe for fish chowder which has survived into a number of modern cookbooks. And does that give us the recipe? Hold on. Okay, I don't think so. Oh, it does. Okay, wait, there's a footnote. All right. So here's the recipe that they're citing here. Take a cod of 10 pounds, well cleaned, leaving on the skin. Cut into pieces 1.5 pounds thick, preserving the heads whole. Take 1.5 pounds of clear fat salt pork, cut in thin slices. Do the same with 12 potatoes. Take the largest pot you have. Well, that could be a challenge. Imagine like the Guinness Book of World Records reading this recipe, and they're like, try out the pork first, then take out the pieces of pork, leaving in the drippings. Add to that 3 parts of water, a layer of fish, as to cover the bottom of the pot. Next, a layer of potatoes, then 2 tablespoons of salt, 1 teaspoon of pepper, then the pork. Add another layer of fish and the remainder of the potatoes. Fill the pot with water to cover the ingredients. Put over a good fire. Let the this doesn't work on a modern stove. You have to light the fire. Let the chowder boil 25 minutes. When this is done, have a quart of boiling milk ready, and 10 hard crackers split and dipped in cold water. Add milk and crackers. Let the whole boil 5 minutes. The chowder is then ready to be first rate if you have followed the directions. An onion may be added if you like the flavor. But just throw the whole thing in. This chowder, he adds, is suitable for a large fishing party. And that is from the Wolcott the Yankee Cookbook from 1939. Oh, man. All right, so that was footnote up here. It survived into a number of modern cookbooks, which was 1939, according to 1964 when we're reading this. That was modern cookbooks, and in which the removal of fish bones is not mentioned at all. One old-time recipe recited in the New English Dictionary study defines chowder as a dish made of fresh fish, especially cod or clams, stewed with slices of pork or bacon, onions, and biscuit. Cider and champagne are sometimes added. That's from Hawthorne in the House of the Seven Gables. And someone who coincidentally has the last name Bacon. And, oh, this is another book, actually. Here they speak of a codfish of 60 pounds caught in the bay, which had been dissolved into the rich liquid of a chowder. A chowder variant. We are waiting, by the way, you guys. We are waiting for them to come back. They are, if you're wondering, they're doing research on what the statute said in 2001 and if any changes since are retroactive or what. So we've got, where were we? Now we're just reading a 1964 case about a lawsuit that someone found a bone in their clam chowder at a restaurant. They say, let's see. A chowder variant, cod muddle, was made in Plymouth in the 1890s by taking a 3 or 4 pound codfish, head added. Season with salt and pepper and boil in just enough water to keep from burning. When cooked, add milk and a piece of butter. The recitation of these ancient formulae suffices to indicate that in the construction of chowders in these parts in other years, worries about fish bones played no role whatsoever. This broad outlook on chowders has persisted in more modern cookbooks. The chowder of today is much the same as the old chowder. In the American Woman's Cookbook, the all-embracing Fanny Farmer states in a portion of her recipe, fish chowder is made with a fish skinned, but head and tail left on. Cut off head and tail and remove fish from backbone. Cut fish into 2-inch pieces and set aside. Put head, tail, and backbone into broken pieces in stew pan. Add 2 cups cold water and bring slowly to a boiling point. The liquor thus produced from the bones is added to, they call it liquor back then, instead of like broth. The liquor thus produced from the bones is added to the balance of the chowder. Thus we consider a dish which for many years, if well made, has been made generally as outlined above. It is not too much to say that a person sitting down in New England to consume a good New England fish chowder embarks on a gustatory, all right, they're back, you guys, with a folder. We are back with the folder and a ginger ale.
Exactly. All right, we're going to go back on the record. I'll speak to the state first. Anything else the state would like to add with regard to my comments about what is now the statute 1710.6.1?
Yes, Your Honor. And I looked at 2 cases during the time period the court gave us. The first is Velasquez v. State. It is a 2007 Court of Appeals case out of Georgia. The citation is 283, Georgia Appeals 863. There's no negative treatment for that case noted on Westlaw. And also Henry v. State, which is a Court of Appeals case from October 13th of 2017. And the citation on that is 343 Georgia Appeals 157. In Velasquez, the court states that, and Let's see. Our Supreme Court held in State v. Ingram, 266, Georgia 324, that a life sentence without parole was authorized only in cases in which the state first sought the death penalty, and we are bound to follow that precedent. And then in Henry, which is a case in which a life without parole sentence was imposed, but due to a 1710(7)(c) recidivist situation, the court, again discussing Velasquez, states that Henry is correct that under normal sentencing, a trial court may not impose a sentence of life imprisonment without the possibility of parole unless the state sought the death penalty in the case. I did see some of the cases which I think the court is making reference to. In the way that they read in the time period that we had, it seemed to be a situation in which the jury had found or not found, or the court had found or not found, aggravating sentencing circumstances that refer back to the death penalty statute's definition of aggravating circumstances. So, there's always the possibility that I'm wrong, but it is my belief, although if the court were authorized to impose a life without parole sentence, I wholly think it would be appropriate under the circumstances of this case. However, I do believe that I have a responsibility to represent to the court what I believe the law to be, which is that we are limited to a sentence of life on both the murder but also the rape. Thank you, Judge.
Thank you. All right, Mr. Cruz, anything else that you would like to say? This is a legal issue, but we need to make sure we are certainly following all the requirements of the law, particularly as it relates to what the legislature intended in 2001. Go ahead, sir.
Thank you, Your Honor. I don't think I have a position here because we're not asking for a life sentence when it comes to the rape charge, Your Honor.
Okay. All right. Thank you, sir. The reason that the court wanted to ask counsel to look at the law on that is because both sides are, of course, diametrically opposed, really with regard to count 8, which is the rape count. And the court had a memory of some of the law from 2001 as it related to sentencing. 1710 6.1 was a different statute in 2001, but the idea of 1710 6.1 was the same back then in 2001, and that particular charge, rape, falls under that statute as a serious violent felony. There are orders, particularly one out of the Superior Court of Clarke County, that which was not overturned, supports the notion that under the recidivism notice and statute, that a maximum sentence for a rape charge back in 2001 supports the possibility of life without the possibility of parole. The question then becomes, if that is correct, is whether the recidivism relates back to anything prior to 2001, or does it relate to something after 2001? And so that certainly can be up for debate, and we're not going to debate that now based on the state's not seeking that maximum sentence. The maximum that they are seeking in count 8 is life, and so we will leave it at that. But that is the reason I wanted to ask both of you to look at the law and see really what was applicable in 2001, because both parties, of course, are diametrically opposed in terms of the maximum and minimum amount the court can allow.
Yeah,
All
the
right.
3 cases
With
that
being
were
said, Mr.
in the
Young,
notice were
anything
later
else
than
from you?
Nothing further from
January
the state,
28th,
Your Honor.
Thank you,
2001.
Mr. Cruz. Anything else, sir?
No, ma'am, we'll just note for our record the recidivist notice objection that we made.
3
prior.
cases.
I understand, Mr. Cruz, and I want to respond to that very quickly. Looking online to make sure that my notes comport with what I saw online, the notice that the state referred to in their discovery, which was filed with the court, was from April the 2nd of 2025. It was entitled The State's Notice and Recidivism Notice in Discovery. That was from April 2nd of 2025. The notice that the state is relying on now, that the defense has responded to, of course, the 3 felonies that they have enumerated in their notice, is from October 2nd of 2025. And so anything further, Mr. Cruz, you'd like to say about that? All right.
No, ma'am.
All right. Thank you. All right, very good. All right.
Make the record clear. So from October 2nd, 2025, it's aggravated assault, VGCSA, 2 counts of violation of Georgia
The 3
Controlled
cases.
Substance Act offenses. Looking at the recidivism statute, I'm just saying, these are the offenses that we have notice of. The state has asked the court to take, to consider other offenses that there was no notice given. The state's argument when we brought this up initially was that, hey, in discovery, we just filed a general notice and whatever could be used as for purposes of recidivism. Our argument, it does not. It has to be specific. So we are on notice of these 3 specifics.
Thank you. All right, so I just want to respond to that very briefly. The law allows the state to provide notice in the manner in which it did. From April the 2nd of 2025, their general notice in their discovery that they filed with the court, and of course the actual notice that they provided the defense on October the 2nd. I will say, however, that the court is going to take into account in sentencing Mr. Faust the notice that was filed October 2nd that the defense has no objection to, and that is the one that I will certainly take into account in sentencing. With regard to this case and sentencing and taking into account the notice that was filed on October 2nd of 2025, the state's argument about sentencing and the defense's argument about sentencing, the court finds as follows. Mr. Faust, please stand.
I think she did that to make it unchallengeable, saying
This
she's
court
only relying
finds,
on
based
10-2.
upon the evidence presented at trial and the jury's verdict, that a sentence involving rehabilitation is not appropriate in this case. And I'm going to sentence you, Mr. Faust, as follows. With regard to count 1, life. Counts 2 through 5 are what we call in the legal world vacated. That means no sentence, and that is imposed as a matter of law. Those are the felony murder counts. With regard to count 6, which is the burglary charge, 20 years consecutive to counts 8 and 10, which I will get to in a moment. With regard to count 7, which is the first aggravated sodomy charge, 30 years, and 20 years is 20 years confinement. Count 7 is 30 years in confinement. That is concurrent with count 1. Count 8, the rape charge, is life. That is consecutive to count 1, which is the other life sentence. With regard to count 9, the court agrees that count 9 does merge with count 1 as a matter of law, and that's the aggravated assault charge. With regard to count 10, which is the other aggravated sodomy charge, the court imposes 30 years in confinement. That is consecutive to count 1 and 7. That is also concurrent with count 8. Count 11, which is the arson and the first degree charge, the court imposes 20 years of confinement consecutive to count 6. And count 12, which is possession of a knife during the commission of a felony, the court imposes 5 years in confinement. That is consecutive to count 11. The order of the court are 2 consecutive life sentences to be imposed, plus an additional 45 years to be served in confinement. That'll be the order of the court. You are in custody. Thank you. Court is adjourned. And everyone, please remain seated until the Sheriff's Department determines who can leave and when they can leave. Thank you very much for your cooperation.
The goat screams. Well, and we will continue. I mean, anything I see, any updates, of course, I'll share with you guys. I don't have like any, I don't have any knowledge of what next steps will be. I would imagine that they themselves are still trying to figure that out. So there's that. If she didn't, yeah, no speech. So, but maybe she's ready to go, right? Because it's 5:30. We can end with the Reasonable Doubt song if you want. For anyone that hasn't heard it, it's from the Christopher Wolfenbarger trial, not from this one. But we can end with that if you guys want that. Yeah, next step is Cruz withdraws. I really do think that that was part of his, either he was trying to buy time for the two witnesses that were on their way but hadn't quite arrived yet. Or he did that to, or maybe to say like, hey, there were things that the jury wasn't able to see, like painting on the record that IAC claim. So yeah, absolutely. If there's arguments for the appeal, we will all be back here, of course. Yep, 30 days notice to appeal for 4 years for the habeas corpus. Yeah, it's true. It's like, I'd get right in the Court of Appeals and say the judge never knew the law and could never quote it. To heck with the law. So, we can see, I mean, let's see if they cut the feed. Well, actually, let me pull up like a local. Let's see. Let's see if 11 Alive is going to set up outside. No, I don't actually even see them doing a live feed of the sentencing. Let's see if WSB TV has a feed. Yeah, I don't see any of the local stations live. It was just Law and Crime. Unless you guys see someone. So. Oh, hold on. I'll drop the Discord link. Let's see. There we go. So the Discord link's in the chat. And yeah, just so you guys know, I mean, with the case ending, what I'll probably end up doing is move the case conversation. I mean, I'll keep it there for a little bit, but I'll end up doing like a docket. I have like a little docket, like it's hot section in the Discord where it's just like posting updates on cases for when things are kind of spaced out. So that's where I'd post information. I'd of course share it on YouTube, and if there's anything more than like a 1-sentence update, I would do a video on it. So yeah, I don't think that result was surprising. I mean, the numbers there keep him outside the realm of anything meaningful. He's not gonna like, oh, you've done 80% of your sentence. Like, that's just not gonna happen. So also, again, the fundraiser, if you can and want to contribute, the fundraiser is pinned on the top of the chat. If you're on Replay Crew, it'll also be in the description. And I think that's the end of sentencing. If you guys are new to watching this channel, I do like to cover, I watch trials, don't get me wrong. I watch a lot of trials, but I really actually like to look at appellate arguments. I like to read motions. I do like to look at stupid little cases. This wasn't just something, you know, this is a good chat suggestion while we waited, but it is stuff I like to look at generally too. So if you ever have stuff like this, send it my way. We can read it online. Very cool suggestion here, I think, to go back and read the way this was written and the way that they were looking at things in 1964. So this was an awesome suggestion. I've also loved everybody participating in the little debate about the different clam chowders and the better type of wing in the chat. The resolution here, I think, was also a bit of levity. It gave us a bit of levity on a tough subject today. So to finish this out, I feel like it'd only be proper. We only had like a paragraph left. So we'll finish this one for good measure. They say, thus we consider a dish which for many years, if well made, has been made generally as outlined above. It is not too much to say that a person sitting down in New England to consume a good New England fish chowder embarks on a... Oh wait, we were down further, right? Yeah, we were down here with the case law. We should be prepared to cope with the hazards of fish bones, the occasional presence of which in chowders is, it seems to us, to be anticipated, and which, in the light of a hallowed tradition, do not impair their fitness or merchantability. While we're buoyed up in the conclusion by Shapiro v. Hotel Statler Corporation, I wonder how old this case is, in which the bone which afflicted the plaintiff appeared in hot barquette of seafood mornay, we know that the United States District Court of Southern California, situated as we are upon a coast, might be expected to share our views. We are most impressed, however, by Allen v. Grafton. This is in Ohio, where we just read the Ohio bone in the chicken case from recent years. The Midwest, in a case where the plaintiff was injured by a piece of oyster shell in the order of fried oysters, Mr. Justice Taft, now Chief Justice, in a majority opinion, held that the possible presence of a piece of oyster shell in or attached to an oyster is so well known to anyone who eats oysters that we can say as a matter of law that one who eats oysters can reasonably anticipate and guard against eating such a piece of shell. Thus, while we sympathize with the plaintiff who suffered a peculiarly New England injury, the order must be exception sustained, judgment for the defendant. So there we go. Thank you guys for having something a bit. I didn't like leaving the stream on Tuesday in such a bad way. So I hope everybody's doing well. I hope everybody's doing something too. If this case is affecting you, finding something to give you peace of mind. Always got to keep going. Can we get Steele on this Faust case? I mean, if he's interested in this case, I would not be surprised to see him pop up. Ultimately, it's going to be Faust's decision on if he wants to retain appellate counsel. If enough money is raised, it'd be his choice. So, let's see. We've got who's running the fund. So it was shared by Cruz and also Colin Miller. And to be clear, Colin Miller is not appellate counsel. He's offered pro bono services, and he's done work with cases where he's simply been a consultant. But both of them, Attorney Cruz and Colin Miller, have started the fundraiser. So, and then there we go. Let's see. Guys, I'm going to wrap this one up. If you're looking for something to hang out with tomorrow, I am looking at Scott Spivey and the Stand Your Ground. It's a civil hearing, right? But it's a Stand Your Ground immunity from liability in a wrongful death lawsuit, a road rage type shooting. The facts are in dispute. So both sides are arguing. Mark Tinsley is representing the plaintiff. It's South Carolina, so hearing the lawyering, and then it's in front of a judge since it's not a trial. So it's just a hearing. It's been interesting to watch. So if you want to do something different tomorrow, that's probably what we'll be doing. Unless there's cameras in court for the Courtney Clenny hearing, then we'll tune into that. Other than that, I hope everyone, have a good rest of your day. Take care. If you see anything interesting, let me know. If I see any updates on Faust or anything else that might be interesting to you guys, I will, of course, let you guys know. So love and appreciate you all. Whether you've been here for a while or just found us today, hope you come back and hang out. Everybody take care.